Okay, once again, good morning or good afternoon to everybody. My name is Gabriel Viola, and I welcome you to the rescheduled webinar titled Condensed Appeals and Grievance Guidance, sponsored by Innovair. I want to thank everyone that attended the original presentation for their patience and understanding as we had to reschedule it due to some technical issues that we had. Again, I want to apologize to everybody, and I want to thank you for rejoining us today. Today's presentation is going to run about 40 minutes, allowing for questions at the very end. We will put all the phones onto mute throughout the presentation, so if you have any questions, please feel free to type them into the chat box. This is usually located on the bottom part of the GoToWebinar page. Or if you'd rather, you're always welcome to email us at info@innovair.com. If you submit a question today and for some reason we don't have time to get to it, please don't worry. We're going to be responding to all questions after the presentation is over via email. So we'll be sending a compilation of all the questions that were asked. We'll have them all answered and sent out to everybody upon conclusion of the meeting. So with all that said, why don't we go ahead and introduce our speaker. Our presenter today will be Stephanie.Donahue. Stephanie has over 12 years of experience in compliance operations in the healthcare industry. We're very happy to welcome her to the Innovair team. But I'm going to go ahead and let her give a little more information about her background. So with that, go ahead, Stephanie, go ahead and take over.
Hi, everyone. Welcome to Innovair's overview of the new appeals and grievance condensed version. As Gabe said, my name is Stephanie.Donahue, and I will be your host for the webinar. I do have extensive experience in healthcare, particularly appeals and grievances and compliance. I know this guidance has been out for quite some time now, but I also know that we've all read the same guidance and seen the previous versions, and you know, I think that we can all gather new and additional information off of something that we've read over and over. So I hope to be able to provide value for you today that you can use moving forward. So let's start with the role of the medical director. This guidance has really been clarified for health plans and in the new condensed version. So section 10.4.2 states that all plans must employ a medical director who's responsible for ensuring the clinical accuracy of all coverage decisions involving med necessity. This means that the role of the medical director cannot be delegated. There must be a medical director who's an employee of your health plan. Though CMS does state that they don't expect the MD to review every single coverage decision, they do expect the plan to establish a clear process for when the MD needs to be involved in making those determinations. So that brings us to a question that we received on this topic. Does a medical director or physician, this is from the pre-webinar emails. So a client had asked, does a medical director or physician need to see all denied coverage determinations with lack of medical necessity, or could it be a pharmacist? And the answer is actually in section 40.0 of the new condensed version, who must reveal initial determination. If the plan initially reviews a request and expects to issue a partially or fully adverse decision based on med necessity, the review must be completed by a physician. And it does go on to state, you know, the section 1861R of the Act, and provide you with the guidelines for what they would consider an appropriate healthcare professional. And then lastly, specifically in the language of 40.9, for Part D only, a pharmacist would generally be considered an appropriate healthcare professional for purposes of meeting this requirement. So in general, the application of a clear statutory or contract exclusion set forth in the plan's EOC does not constitute a decision based on lack of medical necessity. This means basically that if this is a plan benefit determination, it's just strictly not covered based on statutory guidelines or clear plan language in the EOC. That's not going to be considered medical necessity. Conversely, if it is information where we're needing clinical documentation to support the request, or it's being denied because it was insufficient medical documentation or the criteria wasn't met, obviously that will be considered a denial based on medical necessity. So again, if it's just statutorily excluded or excluded in the EOC, a pharmacist would be able to make that determination as well. And then the last clarification on the role of a medical director. So here we're just going back to the role real quick to wrap that up. The medical director's overall responsibility encompasses being involved in multiple aspects of the plan's policies and operations. And a few of those responsibilities would include medical and utilization review. They have to be a part of the formulary administration process. They should have, involvement in provider or prescriber outreach, staff training, etc. So the new guidance does explicitly list out some areas where the medical director should be involved and have overall responsibility. So section 10.4.3, of course, as you all know, the health plan is responsible for its delegated entities' actions. 10.4.3 cites that the plan must have a comprehensive and ongoing monitoring and auditing process in place to validate that their delegated entity is compliant with all CMS requirements. So in addition to this, you just have to be sure that they're being member friendly and doing what they need to do for your members overall. And delegation oversight doesn't just mean regularly attending meetings to discuss various items or having them provide you their P&Ps and monitoring volume. This is ensuring that you have a comprehensive and ongoing monitoring without just, looking at policies and procedures. You actually have to review those P&Ps, make sure they're abiding by them. One great way to do this is to have to keep your delegated entities kind of on track and making sure that they can demand those CMS universes within a quick time frame that you will be required to do. Just have them submit monthly universe files to you, and then do random retro reviews of case files based on those universes. So it kind of accomplishes many things. You're making sure that your delegated entities have all the required elements and can quickly get that information to you. And then you also have your samples then right in front of you that you can choose from and do a retro review of the case files. And then plan communication to an enrollee. One really exciting option that we were given as health plans is that you now may communicate with your members via email. For one, I think this is great, and it's pretty exciting. For one, this generation is getting more and more tech savvy. I mean, look at teledoc, telemedicine. They're starting to schedule transportation benefits through Uber and Lyft. So they're starting to really embrace the technology. But if you're close to meeting turnaround time, you don't have to wait for the courier to pick up either. Of course, there are some cautions or things that you should put in place to protect the member's PHI. Don't just, send without getting the authorization from the member. Make sure all of that is documented. But another thing, have cautions or things to put in place to protect the member's PHI. Don't just put PHI in the subject line, and be sure to work with your compliance and legal department to ensure that you're following all HIPAA guidelines. In addition to this, make sure to point out that, or just be sure to reference the marketing guidelines regarding electronic communications as they have outlined in there. But I really think that if this is utilized, if it's documented accordingly, you follow all those HIPAA guidelines, that this could really be beneficial to you as an organization. Calculation of dates for assessing plan timeliness. So it does go on to state section 10.5 for standard cases. That includes level 1 appeals and standard grievances. The day the plan receives the request is not counted as day 1. And of course, this had quite a few questions generated to us. One question from the audience: of all the 2019 changes in the condensed appeals and grievance guidance, The impact of section 10.5.2 is one where our plan is most interested in interpretation. Everyone is, for sure. Specifically, the language regarding when the processing timeframe begins for an expedited appeal. The new guidance states for expedited requests, the processing timeframe begins when the appropriate department receives the request. Does Enrollee have any opinion on this change? And the answer is yes, we do. So as the audience had pointed out, the chapter does state for standard requests, the processing timeframe begins when the plan, any unit in the plan or delegated entity receives the request. For expedited requests, the processing timeframe begins with the appropriate department receiving the request. So there are a few caveats to that. For one, as we all know, health plans are to make their determination based on their members' health as their health requires. So if this is something, even for expedited, if you have 72 hours and your member clearly needs an answer prior to then, you know, CMS has made very clear that it's based on the member's health. So that needs to be made quicker if necessary. But in addition to that, it does go on to state the plan material should clearly state where all requests should be sent. That includes EOC, website, etc. And the plan policy and procedures that the organization has in place should clearly indicate how to route requests that are received in an incorrect location to the appropriate location as expeditiously as possible. So if you're a health plan that accepts walk-ins where a member can just walk in and speak to a customer service rep, or if you have your utilization management team or clinical team reaching out, you really need to have a policy and procedure that you share with all of these departments on how to correctly identify these types of requests and get them over to the appropriate department as expeditiously as possible. And then another warning, notice that on section 50.2.1, guidelines for accepting level 1 appeal requests, they actually state the exact opposite. On page 55, the last bullet, it specifically states that for both standard and expedited level 1 requests, the following guidelines apply. The processing timeframe begins when the plan, any unit in the plan, or a delegated entity, including one that's not ultimately responsible for processing the request, or whether they're delegated for that particular task or not, doesn't matter. It starts as soon as they receive that request. So again, it makes very clear on page 55 for both standard and expedited, it begins when the plan, any unit in the plan, or the delegated entity receives it. So another question for expedited requests, the processing timeframe begins when the appropriate department receives the request. And the question provided an example. The appropriate department means, for example, customer service. If they receive a call with a drug request at 8 a.m., then they send the request to pharmacy at 2 p.m. same day. Would the receive date time be 2 p.m.? And the answer is based on the previous slides. The answer to this question would be 8 a.m. start time. For one, expedited requests must be accepted verbally. Most of the time they'll come in through customer service. And this is a department that CMS expects to be truly highly trained. That's how a lot of those expedited calls or requests are going to be coming in. So this is the department that should be trained, as I stated, and they must be trained on how to thoroughly document the call, identify the issue, and then redirect to the Appeals and Grievance Department immediately. And additionally, based on the contradicting language, I would think CMS is going to be providing clarification on this contradicting language, because they were very clear in the previous chapter. I think that should be forthcoming here pretty soon. Next is good faith efforts to provide verbal notification. So plans may satisfy the notification requirement by first providing verbal notice of its decision to the enrollee, so long as the written notification requirements are met. And so that means the good faith effort needs to be documented in writing and included in the case file. The written notice of the decision has to also be sent to the enrollee or the representative within the applicable time frame. And the plan cannot be at fault for its inability to reach the enrollee by phone. So that means if you are trying to make outreach and you transcribed the phone number incorrectly. It can't be the plan's fault on why they didn't reach that enrollee. So as long as you make those good faith efforts to provide that verbal notification and you are not at fault, they're going to consider that requirement as being met. Good faith effort to provide verbal notification. The question from the audience regarding this piece was when a plan is unable to contact the member during oral notification. Is this new guidance just to clarify the need for documentation and the need to send a letter within the applicable time frame? Applicable time frame means case due date, but is not adding 3 extra days for written notification. Is that correct? And so the answer is that the good faith oral notification requirement just clarifies what counts as good faith. It's just repeating the fact that the health plan is ultimately responsible for making sure that the member's phone number is accurate and up to date, that you make those multiple attempts at different times of the day, etc. So as long as it wasn't due to your own error, then you satisfied your verbal requirement. And also as an FYI, I'm sure that most of the health plans know this, but for reporting purposes and the verbal notification field for the CMS universe, the CMS has directed to enter the last good faith effort attempt that was made during the turnaround time. So if you made your third attempt within an hour of making turnaround time, the letter went out, etc., and then you get a phone call back from the member, which happens a lot, the very next day or 2 days later, and you actually have a successful outreach with the member, you're going to still use that last good faith effort attempt because you satisfied that requirement. So this is pretty exciting too. So section 20 of representatives, I know that for grievances in particular, the customer service department struggles often because the member will call in and then the daughter or son is standing right there, just hot to trot, ready to, gnawing at the bit to talk to the customer service rep. And of course, they don't have any documentation of being able to communicate anything to the purported rep. And the member, doesn't provide anything. So the customer service rep takes that information from the son or daughter who's not authorized to speak on the member's behalf and send it to the A&G department. Then the A&G department is constantly attempting to get assigned AOR or other equivalent documentation. This new clarification in section 20 is really great because it's going to reduce a lot of back-end work for the A&G rep or whoever's sending out that AOR request. You can just go on ahead and take the complaint from the member's son or daughter, for instance, and get verbal confirmation from the member that they do, in fact, want to file that request. And you can just go on ahead and start working it. They do clarify that all communication, written and verbal, must be delivered to the enrollee until a valid written rep form is on file. But in instances such as this, you just mark it as a member grievance and you just work it. And then you address the resolution or any type of communication to the enrollee instead of the purported rep. So remember, and during this process, you don't have anything in writing, authorizing the disclosure of PHI. So you just go on ahead and work it as a member grievance, you mark it as a member grievance, and you respond to the member directly. Missing or defective representative forms. So we already know this piece, but they break it down, Part C versus Part D. Appeal requests may be dismissed, but the plan should notify the enrollee and the person asserting rep status of the dismissal in writing. So for Part C only, they do have a may versus must going on here. Part C only, the health plan may explain in the dismissal notice if the representative documentation is submitted after the 60-day filing deadline for requesting an appeal has been expired, a good cause statement explaining why the form was not filed timely should be included with the request for an IRE review of the dismissal. But for Part D, you must send a written dismissal notice stating the reason for dismissal and explain if the representative documentation is submitted after the 60-day filing deadline. A good cause statement explaining why the form was not filed timely should be included with the requested documentation. So you're directing the member in the dismissal notice what to include in the appeal for the dismissal. And again, it's a may versus must. For withdrawn grievances, I'm glad they finally put this in black and white. Section 30.4, if the plan receives a verbal request to withdraw a grievance, it is highly encouraged to document that the enrollee does not want to proceed with the grievance. And of course, most of you know there's a trend here, as there always is. Make sure everything is documented. I know most of you already know this, but it's worth repeating because I do know we have a couple of new health plans on the call. There is almost no such thing as too much documentation. Of course, I say that because you don't want to be attaching multiple internal emails to a case file or a huge email chain. That does nobody any good. In fact, it leaves you open to an auditor somehow getting a hold of that, and it just creates confusion when you're trying to talk through a case. But this is guidance that also makes you cover yourself. Further on, it states the plan should, but is not required to, send a written confirmation of that withdrawal to the enrollee within 3 calendar days of receiving their withdrawal request. So you're really covering yourself here. You're saying, yes, member, we acknowledge this withdrawal request. Here's confirmation that we're acknowledging your withdrawal request. And then it allows the opportunity for the member to read that and say, you know what, I didn't mean that. I didn't mean to withdraw that piece. And, you know, then you can go on ahead and just make sure you have open lines of communication and you're documenting everything. Quality of care, they do say still needs to be investigated, but the plan is not required to notify the enrollee of the outcome, which is fine. I mean, if you're responding to a quality of care after they withdraw the complaint, you're really just telling them you've investigated the complaint. The only thing that you want to make sure that you do, obviously, is provide those QIO rights, and your customer service reps should be doing that on the front end when they get those anyway. But hopefully this guidance helps customer service specifically quite a bit. And even though, one more thing worth noting, if you decide to follow the should and send that written confirmation within those 3 calendar days, you really need to be consistent. It really needs to be sent within those 3 calendar days, and you need to do that consistently with each member's grievance that's withdrawn. You can't use the excuse that the guidance states should, and you do for most of your cases, but you didn't do it for this one that was pulled for sampling. So it has to be all or nothing, and you need to have a good policy put in place and follow that policy every time. So effective failure to meet the time frame for an initial determination. Of course, this is the initial determination. This has nothing to do with an appeal yet, but the Appeals and Grievance Department should ultimately be responsible for all appeal rights that should be provided to the member. So this guidance states that the Medicare Advantage plan must explain in its EOC that enrollees have the right to a level 1 appeal if the plan fails to provide timely notice of the initial decision. And then, of course, as most of you know, this constitutes an adverse decision for reporting purposes. But in the EOC, ANOC, wherever it may be, if the member has a specific right to a level 1 appeal, and in this instance, if the Medicare Advantage plan fails to make a timely notice of the decision, you should really be the one educating, and when I say you, I mean the Appeals and Grievance Department should really be the one educating and making sure that the UM department or the claims department, whoever it may be making that initial determination, you need to make sure that they understand that those rights need to be provided to the member on the initial decision. Just make sure you check that as you would the EOC or the website info. This is something that I think the A&G department should at least make sure they do. guidelines for accepting level 1 appeal requests. This is a very handy sheet they gave us, or chart, however you want to call it. It clarifies, when you have a right to receive or accept a request and when you don't. For instance, we all know that plans must accept written requests, both standard and expedited. The plan may accept standard pre-service verbally, but the plan must accept expedited verbals. This doesn't mean that you have to accept the expedited appeal request and treat it as expedited. They do say, though, that if the member calls in and wants to do an expedited verbal, and you say, you know what, no, you do not need these compression stockings are not expedited. You do not need an expedited appeal. You actually can't make them refile the request in writing. Instead, you're supposed to accept the appeal request and automatically transfer that appeal to a standard request. Of course, most of you know now, here's the kicker. This would be a downgrading. And if you're downgrading from expedited to standard, then of course you need to provide them with their expedited grievance rights. Mark the request accordingly in your ANG database that it's an expedited to standard downgrade for reporting purposes. And of course, the scary warning from this guidance, as well as it always really has been, if you do accept verbal requests, standard or expedited, you must have a policy in place for your customer service rep or ANG, whoever's receiving it, that includes repeating the request back to the member to ensure that this has been accurately captured and documented. Make sure that you've included everything that the member feels is necessary as part of the appeal. And CMS has stated if you fail to take these reasonable steps to ensure accuracy, then they will find that you have inadequate policies and procedures and be in violation of the CMS contract. For acknowledgement letters, this provides additional information on where to submit additional information that the member would feel would be helpful to their case. This is nothing new to remember, but still something to keep in mind. For Part C plans, an acknowledgement letter should be sent to the enrollee to confirm receipt of the appeal, to confirm the facts and the basis of the appeal, and to instruct the member to call the health plan back immediately if the acknowledgement letter doesn't accurately reflect or capture the member's request. That's in section 50.5.2. Again, this is just something that CMS makes sure you're constantly you're keeping your members informed, you're making sure that you're doing your due diligence to communicate and understand what the member is requesting. How to request or how to process requests for expedited level 1 appeals. If an enrollee misses the deadline for immediate QIO review of an inpatient discharge, then the enrollee may request an expedited reconsideration with the plan. This is nothing new either, but they are a little bit more clear. Medicare Advantage plans should have a process in place to distinguish between misdirected requests that should go to the QIO or requests that the plan should process. So of course, usually you get these QIO appeals at 4 o'clock on a Friday. I totally get it. 4:30, you're walking out, closing everything up, you get it. Obviously, you should first go down the list as usual and ask yourself the relevant questions. Did they receive the NOMNIC? Was it signed by the appropriate person? Were they given their 2 days notice with the NOMNIC, or was it just signed yesterday? I mean, those types of things, you know, you should be going through first and foremost regardless, just to check everything off the list. And then you need to ask yourself, is this still within the time frame for them to file an appeal with the QIO? The QIO is the first level, the first line of defense that they should have, and that needs to go directly to the QIO if they still meet the appeal time frame. But they're saying in the guidance, much more clearer than the previous Chapter 13, if the member or the rep has exceeded the QIO appeal time frame, the plan is to accept that appeal, and they are encouraged to automatically expedite all valid requests for reconsideration. So that's kind of common sense too, right? I mean, in this case, we're talking about a member or the purported rep appealing an inpatient discharge, clearly this is urgent. You really need to start working on it accordingly. And again, it does state strongly encouraged to automatically expedite. And responsibilities with contracted providers. So page 59 of the new guidance states that Medicare Advantage plans are expected to have sufficient and appropriate contract terms in place with their contracted providers so they can ensure that they get information and records, necessary records for grievances and appeals. The Medicare Advantage plans should not generally or regularly extend the time frame. CMS does state that they expect their contracted health plans, contracted providers to be in the control of the health plan. So unless there's, extraordinary or non-routine circumstances that justify why that contracted provider was unable to submit information to the health plan in a timely fashion, like I know I've seen provider medical record databases go down. That unfortunately does happen, sometimes a little too often, but that would be an example of, allowing an extension. But you really need to be able to track and trend how often, your database should allow you to track and trend how often you request medical records and which providers are really the bottleneck to information, and then address those contracted providers accordingly. I can't stress enough, CMS's expectation is that you have control over your contracted providers to the degree that, the contracted provider should be educating something that's not Medicare covered. They should be educating the member and not referring them to services that are not covered, et cetera. So this is just one of many where the provider is an extension of the plan. Enrollee requests for case file content. The rule is the plans must provide the parties of the appeal with a reasonable opportunity to present evidence related to the appeal. Though they're not required to submit additional information, each party may exercise their right to do so. Again, we know that, but in the case of an expedited level 1, the opportunity to present evidence is limited by the short time frame for making a decision. And yes, this, again, usually you get these on Fridays, that's even more limited. But you should really inform the parties, actually, it's not a should, you must inform the parties of the conditions for submitting the evidence. So when you get that expedited appeal, that party needs to be informed of their right to submit additional information, of their right to request case file content. And then here's the bigger kicker. This is new. On Part C only, a Medicare plan must inform the party of their right to request a 14-day extension if the party feels they will need additional time to submit the evidence. This is going to be difficult. This is going to be something that you're going to have to make a business decision on. How are you going to notify or inform the party of their right to request a 14-day extension? Are you going to be doing this through customer service if it comes in via phone call? Are you going to be making outreach to the member, especially on Expedited in the Appeals and Grievance Department, letting them know of the right to request an extension? It's going to be done through an acknowledgement letter, the original denial notice, the EOC, ANOC, or other marketing material. I'm not quite sure if that would satisfy that because, what members actually read that? But it's just something that you're going to have to think about how you're going to put that in place, because it's a must, it's not a may. You have to inform the party that's appealing of their right to request a 14-day extension if they need more time to submit the evidence. So we all know that failure to meet the required time frame constitutes an adverse decision. Remember when we used to send the model notice of appeal status if we missed the appeal time frame and had to auto forward? Well, now they're saying that we're not required to do that. So for Part C only, Medicare plans are not required to notify beneficiaries upon forwarding cases to the Part C IRE because the IRE is going to be responding. We all know, though, that the IRE does not provide a timely response, quite honestly, to the level 2 appeals, or in this case, auto forward. But even though they will get it, we really don't know when they'll get it. So I personally would suggest opting in. As the next bullet point states, Medicare Advantage plans opting to inform parties when a case has been forwarded to the IRE may use the model notice of appeal status, because you know that member is going to constantly be calling to check up on the status of their appeal. And if you're not informing the member proactively or in a timely fashion, you're going to be addressing multiple grievances because the member's now upset that it's taking longer to get a response or to get a decision longer than what it should have. They could potentially file a CTM. So just reduce the risk, in my opinion, and just keep the member informed. And then for Part D, plans should notify the enrollee that the appeal decision was not made timely and is being forwarded to the IRE for review. So this one's nothing new. Use the notice of case status letter to send to the member in lieu of the adverse decision notice. And you do have to send this within 24 hours of the expiration of the time frame. Service of benefit received prior to notice of decision. This is nothing new either, but I did notice that a lot of health plans did not really catch this in the previous guidance. For Part C, if an enrollee requests a standard pre-service reconsideration, but you become aware on the back end, whether it's through a phone call to the provider to get additional information or from the member, if you become aware that that member has received those services before you complete your appeal review, you should stop processing and dismiss. This is now a pre to post issue. And in the dismissal letter, you could state something to the effect that, please be advised, we found that you've received these services. This is now a pre-service to post-service issue. You can direct them to have the provider, or they may submit the claim or information for consideration according to the plan benefit. So then, of course, if they're still dissatisfied with the claim processing, they can submit an appeal request for reconsideration of the post-service determination. Just something along those lines, obviously letting them know the next steps, what those steps would be, and then if they're not happy with that, they still have the right to appeal. It kind of calms them down a little bit. And then for Part D, it's kind of the same thing. If an enrollee has requested a standard pre-benefit redetermination, and the plan becomes aware that the enrollee has obtained the prescription drug before it completes its redetermination, the plan sponsor must stop processing the claim as a pre-benefit redetermination and process the claim as a request for payment instead. So in Part D, you're not dismissing, you're just reverting back. Part C, you're dismissing. So in the old Chapter 13 guidance, under 10.4.2, under note, it stated all notices or other correspondences intended for the enrollee must be sent to the enrollee's rep instead of the enrollee. However, the new guidance in Section 50 states that plans may provide notice to both the representative and the enrollee. This really should have been this way all along, because the member is the one ultimately affected by the issue and the rep is just assisting. So they should really be both kept in the loop during the entire process. So the may provide, that you can send to both the rep and the enrollee when it's a favorable or adverse decision. But again, for dismissals, you still need to send to both the purported rep and the member. And the special note in here is one of importance and significance. Timeframes and responsibilities for forwarding case files to the IRE. If the plan makes a fully favorable determination in less than 24 hours after the end of the applicable adjudication timeframe, the plan should consider promptly notifying the enrollee of the favorable decision in lieu of forwarding the case to the IRE. This is just a reminder. Health plans must make reasonable and diligent efforts to obtain the information. That means multiple tries, different times of the day, etc. But CMS is officially putting it in black and white They're allowing you to use the special note with the 24-hour rule as a last resort, and obviously it should be used sparingly. They've made it very clear that if the plan is consistently using or abusing the special note, that they will find the health plan to be in violation of its CMS contract, and obviously it could lead to sanctions and other stiff consequences. So make sure this is very, very sparingly. So in summary, I'm sure you've all caught, documentation is the key. Document everything that you're doing, lay out policies and procedures for those situations previously discussed, and actually follow them. And they have to be followed consistently. If you have, a couple of cases that you aren't following those policies and procedures, they're going to doubt those policies and procedures were effective. And make every effort to communicate in a clear, concise manner to the member what you're doing and why throughout the process. It's not necessarily required, but it's strongly recommended, and it really reduces your back-end work, additional grievances, DTMs, etc. And with that, I will give it back to Gabe.
Thank you, Stephanie. We really appreciate your presentation, and thank you everybody for the time spent in going through it with us. We have received a few questions, so I'm going to go ahead and bring those up now to discuss. So Steph, if you're ready, we'll go ahead and tackle those.
Yep, I'm ready.
Good. The very first one I'm actually going to answer myself. Are the slides going to be available in a handout? And yes, we will be sharing the presentation, the audio, as well as all the answers to the questions after the conclusion of the presentation. They will be mailed out to all the attendees. Okay. Next question we received, Stephanie, is can a pharmacist review a redetermination if it is going to be fully favorable?
So the answer is no. For redeterminations where the initial denial was based on medical necessity, a pharmacist cannot review the redeterm even if it's going to be fully favorable. And then I also know when the issue is the denial of coverage based on lack of medical necessity, the redetermination must be made by a physician with expertise in the field of medicine that's appropriate for the services at issue. That's 42 CFR 423.590.
All right, thank you, Stephanie, for that answer. The next one we received is if we have 24 extra hours after the time frame before auto forwarding to the IRE, assuming it is fully favorable, is it still considered untimely?
Yes, unfortunately, it's still considered untimely, and it will be reflected as such in your universes and in star ratings.
All right, Stephanie, thank you. Again, the next one is, in the new guidance, it states that the plan has to tell enrollees if their request is considered a grievance or an appeal. How should this be done?
Well, this is definitely an organizational decision, but CMS has advised you can do this by like a phone call to the member, acknowledgement letter, or even technically with your decision letter. So most of you do clarify when you send a resolution letter or decision letter to the member, your appeal was or your grievance was, so most of you can fulfill that requirement just based on the resolution letter.
All right. We just heard that for the redetermination universes, tables 6 through 8, SRD, DMRRD, and ERD respectively, the question is, was the request denied for lack of medical necessity was to be answered according to the initial coverage determination? And if denied for lack of medical necessity, was the review completed by a physician was to be used for redeterminations? Is this correct?
Yes, that's correct. Was the request denied for lack of necessity field is to be answered according to the initial coverage determination decision. The second question If denied for lack of medical necessity, was the review completed by a physician, is to be answered according to the redeterm review. I understand it doesn't make any sense whatsoever, but this has now been CMS's guidance.
Thank you, Stephanie. We just have time for one more here. Since we are no longer required to notify enrollees that their case has been forwarded to the IRE for ODAG, what do we enter in the field in the universe that requests the date the enrollee was notified that his or her request has been forwarded to the IRE?
So given the updates that were made in the final C&D rules that became effective on 1/1 and CMS's new guidance, you're to enter NA in the applicable fields.
All right, thank you, Stephanie. We did receive one more request. Will the presentation be emailed to all participants? And the answer to that is yes. All participants will be mailed a thank you for attending the presentation and a link to the recorded presentation. This will also be available on our website at www.innover.com under the Events and Webinar tab. But again, we will be mailing out the PowerPoint presentation to everybody that's been in attendance. You'll have access to the audio file. And again, we will be sending out a response to all the questions that were received and the answer to that to everybody. So again, Stephanie, like I said, that's all the time we have for today. I want to thank you for your presentation and for the effort that you put into preparing this all. I also want to say thank you to our audience for joining us today. We hope you found this information helpful. We will leave the meeting on for a little bit longer in case anybody has a question or wants to write down the email or website so that they can ask an additional question. Again, we're planning on sending out this as soon as we can. If you submit any questions, we'll make sure to answer those and then put it as part of the question and answer sheet that'll be going out. Other than that, we hope to see you at our next webinar. I hope you have a wonderful day. Thank you very much for joining.
Thank you, Gabe, and thank you so much, everyone, for attending. I hope I gave you some value and information you didn't have before. Have a great day.